S&P Dow Jones Indices is an independent benchmark administrator, joint venture between CME and S&P Global. And our business is benchmarks. We have a significant business across the European Union, so we've been very much engaged in implementation at this point. Interestingly enough, I looked at my notes from last year's presentation, and a lot of the same concepts that we talked about last year at this time, before the effectiveness of the BMR, before actually level 2 was even implemented or released, we were talking about these issues, very important issues, issues that go to a core component of the benchmark determination process, and that's data. We've been covering this for quite some time. They're very important to the benchmark determination process and the BMR itself. So what I'm going to work through are 3 or 4 items, again, all pertaining to data. Again, we'll touch on a little bit regulated data and contributions, and again, those were the contributions in particular were the catalyst for the BMR. And we think that the regulated data benchmark definition was a way to distinguish a large category of benchmarks from these contribution-based benchmarks. Note, I think it's important that we don't have an issue with the overarching concept the BMR is trying to achieve. That is, the benchmark administrator is responsible for ensuring the integrity of the data that it uses in the benchmark determination process. We have a very sound track record on this point, but the issues pertain to drafting and specific provisions or requirements that, if interpreted beyond what we feel is the intent of the BMR, could have a significant or material impact on the implementation under the BMR. All right, so these are the 4 that I'll hit on relatively quickly, which is usually challenging for an attorney. Regulated data benchmarks, exchanges, and non-EU exchanges in particular, readily available data, and outsourcing. So again, both the industry and policymakers, the NCAs, ESMA, European Commission, Parliament, Council, everybody recognize the importance of creating a separate category of benchmarks when drafting level 1 and throughout the processes that followed. Right now, the definition still requires the data to be entirely and directly from a list of 7 different options. Although S&P Dow Jones Indices, our organization, feels that the Romanet 7 there under Article, I think it's 3, paragraph 24A, yes, we've read this a few times. We plan on relying on the interpretation that when you source that data from a data aggregator, that you are falling within the regulated data benchmark definition. There is confusion in the industry, and we've been requesting clarity for quite some time now on this. There are, certain exemptions, et cetera, that are afforded regulated data benchmarks, which are important, and again, we feel are in the spirit of the BMR and what the underlying objective of the BMR is. Right now, what we're asking for is to avoid any uncertainty. Let me get to the right slide, wrong way. And we're asking for some clarity, maybe through level 3, that sourcing this raw data via data vendors will not result in a benchmark falling outside the scope of the regulated data benchmark. I think it's important to note that the distinction between contributions and regulated data was done due to the transparency of the process, and there are many across the industry that use this data from data vendors that aggregate data for trading purposes and many other purposes. All market participants use the data. There shouldn't be some reason to carve out, unless you're getting it directly and entirely from this exchange itself, that you would somehow not be able to leverage the benefits of the regulated data benchmark category. The second issue is embedded also in the regulated data benchmark definition, and it's the concept of non-EU exchanges and equivalents. Currently, there are only a limited number of equivalence decisions that we're familiar with that have been taken. And many benchmarks that should be deemed regulated data benchmarks are based on data that comes from exchanges outside of the EU. And without an equivalence decision or for further clarity on this issue, there's uncertainty, and then there are many benchmarks that could potentially not be permitted to be used until an equivalence decision is made. Again, the proposed solution is some clarity through Q&As that data from non-EU exchanges or trading venues can continue to be used until an equivalence decision is met. And that will help a lot of the emerging market benchmarks and many other benchmarks that are created outside with data outside the EU and are used by the EU. The next category of benchmarks, so the BMR identified or characterized two categories of data, quite specifically the regulated data concept and contributions, and this was in level 1 text. There's a lot of data used between these two categories, and the BMR does touch on this at a certain point in the recitals, where it talks about readily available data. It's an important category of data. There is data used that are not contribution-based submissions. And not coming directly from an exchange, impacting primarily fixed income or significant impact on fixed income indices and other asset classes that don't use exchange data. And under recital 12 is where the concept comes up. It's when a benchmark is determined on the basis of readily available data that the source of such data should not be considered a contributor. I think that's very important. Our concern is that the definition, there is no definition of readily available data. And it's a category of data that should be afforded the same exemptions or treatment of regulated data, because when you look at the concept of transparency, it's there. This is data that's not created solely for the purpose of creating a benchmark. It's data that's used by other market participants for other purposes. So there's incentive, there are other eyes on this data to ensure the integrity of the data. So we're hoping to at some point see something that would benefit the entire industry as well as the NCAs that are enforcing these provisions is level 3 guidance again on the definition or what the concept of readily available data means. And that would be input data that is readily available is data that's available to an administrator and not created for the specific purpose of determining the benchmark. This could be subscription-based data or any other kind of publicly available data. Again, we feel that the source of that readily available data addresses the transparency concerns of what we feel the benchmark regulation was attempting to address, and attempting to address when they were dealing with the contributions. The last and I believe final point I would like to make is the concept of outsourcing. And all of these concepts are, we're breaking them down into nuances, but they're all rolled into the data concept and regulated data concepts. Outsourcing is something that, as I mentioned in the first point on the definition of regulated data, benchmark administrators are permitted to source the regulated data from service providers that they outsource the data aggregation to. The level 1 text we feel was attempting to capture this standard industry practice. There are many entities out there that don't have hundreds of pipes from the exchanges coming in, so they leverage 1 or 2 data aggregators to provide this important information to them. However, when there was the outsourcing reference in that definition, and it said that it had to be done pursuant to Article 10, we see a significant issue that arises here, and it's under paragraph 3F. When a benchmark administrator is negotiating agreements with their data vendors, being required to ensure that those data vendors would basically submit to the jurisdiction of the relevant NCA when they're outside of the EU is challenging, to say the least. I think anyone in this room, attorneys or otherwise, who deal with negotiations around data agreements understand that exchanges and others that provide you the data, choice of law provisions and jurisdiction are very sensitive and very challenging. And our concern is that if we cannot get this provision into contracts with our data vendors, we'll be forced to either not use the data and cease the benchmark, or be in breach of the requirements of the BMR without clarity on this issue. The European Commission has recognized this point, and in their November 2016 Call for Evidence report, they noted that third country data providers may be reluctant to commit contractually to grant an EU national competent authority access to their business premises located outside the EU. And as a result, the providers can't be granted regulated data status, which does have a significant impact on benchmark administrators. And it could, for those benchmarks relying on this, basically alleviate the benefits of the regulated data benchmark. Personally, I think, reluctant is somewhat of an understatement, but obviously happy to see that it was acknowledged, because it's a very important concept to be addressed. So what our proposed solution is again, looking for some sort of clarity. We're asking for this concept that we feel is also somewhat common in other regulations, that data vendors not be associated as an outsourced provider under the BMR. That there be some language provided that the purchase of standardized services, subscription agreements, otherwise, that will not be deemed to be outsourcing for these purposes. And I do want to reiterate the fact that, S&P Dow Jones Indices, and I know our sister division, S&P Global Platts, we do not have an issue standing behind the data we use. We firmly believe in the concept that the benchmark administrator answers for all portions or all aspects of the benchmark determination process, but it's these issues that will make implementation very challenging, and at times it put us in a very difficult position.